arbitrationagreements.org. Greetings, and welcome to the fascinating world of international arbitration. You are probably here because you're intrigued by the idea of resolving disputes without the need for lengthy and often complex court processes. Well, you've come to the right place. Before we dive into the ins and outs of international arbitration, please like this video, press the subscribe button, and tap the bell for notifications so you can keep up with crucial dispute resolution topics that can save your business a great deal of time and money. At its core, international arbitration is a method used to settle disputes between parties from different nations. It is favored because it's generally quicker and more efficient than traditional litigation, often offering a significant saving of time and resources. As a method of dispute resolution, it has an intriguing history. The very first recorded instances of arbitration can be traced back to ancient Egypt, Greece, and Rome, showing us that humans have long valued the idea of impartial judgment. Fast forward to the 21st century, and it's a prominent fixture in international business. According to a 2020 survey by Queen Mary University, 97% of respondents preferred arbitration as their go-to method of dispute resolution in cross-border controversies. The process begins when two parties agree to solve their disputes through arbitration, usually by including an arbitration clause in their contract. This way, they've agreed to bypass any court interventions in favor of an arbitrator or an arbitration panel's decision. The arbitrators, who could be lawyers, industry experts, or retired judges, are chosen by the parties themselves or appointed by an institution. Their role is to hear the case, examine the evidence, and make a legally binding decision known as an award. In a 2019 report from the International Chamber of Commerce, they noted that 34% of cases were resolved within 6 months and 77% within 2 years, which is much faster than traditional court proceedings. One of the most appealing aspects of international arbitration is its confidentiality. Unlike court proceedings, which are generally public, the details of arbitration proceedings and the final decision remain private. This feature is especially attractive to businesses wanting to maintain their reputation. What's more, international arbitration awards are easier to enforce globally thanks to the 1958 New York Convention, a treaty signed by over 160 countries. This convention ensures that the enforcement of an arbitration award is straightforward in any of the signatory countries. As we step further into an interconnected global economy, the role of international arbitration only becomes more critical. Whether you're a business owner, a legal professional, or just a curious mind, understanding this field can be an invaluable tool. So the next time you find yourself contemplating global dispute resolution, remember the potential power of international arbitration. Do you need more information about international arbitration? If so, head on over to arbitrationagreements.org. That's also where you can buy the service or program you need right away and begin the dispute resolution process quicker. Now, our association does not provide any legal advice, but give us a call if you or your business are considering opening a new account or case. Also, what do you think about international arbitration? Does it sound like a potential solution to resolving a cross-border dispute? Give us your opinion by leaving a comment below. Don't forget to like the video, hit the subscribe button, and ring the bell for notifications so you can stay up to date about alternative dispute resolution processes that can save you time and money.